Hello friends, today we will be discussing on another important chapter known as torts. See, as you know that there are two types of wrong. One is civil wrong, the other one is criminal wrong. Torts, it takes care about civil wrong. So what is tort? To constitute a tort, the defendant must have done something which he is not supposed to do, or he must have omitted to do something which he is supposed to do. That means there should be either some act or omission on the part of the defendant because of which the plaintiff has suffered some damage or injury. So what are the ingredients for this civil wrong? First, there should be a wrongful act or omission on the part of the defendant. The wrongful act must result in causing legal damage to another. So it is not only sufficient that there is an act or omission on the part of the defendant. The act or omission must result in causing legal damage to another, and the wrongful act must be such a nature that it gives rise to legal remedy. So merely an act or omission will not constitute a tort. It should be coupled with the legal damage. That means the plaintiff must have suffered legal damage, and merely suffering legal damage is also not sufficient. Again, the damage should be recognized by the law. That means merely act or omission is not sufficient. It should be coupled with the legal damage. So that means the wrongful act must be of such a nature that give rise to legal remedy. So even though if I commit some wrong, if there is no legal remedy available in the law, then you cannot prosecute me for civil wrong. So all these three ingredients are very, very important to constitute a civil wrong as such. That is, there is an act or omission which results in legal damage, and that should be recognized, or there should be a legal remedy for such legal damage in the law as such. Next we will see what is wrongful act. Wrongful act means the act complained of or should under the circumstances be legally wrongful, not morally wrong. So to say that there is a wrongful act, the wrongful act should be a legally wrong and not moral wrong. So what is legal wrong and what is moral wrong? For example, when you are driving your motor car on the street, if you find a person who has met with an accident and nobody has attended that victim, and if you also just look at him and pass through without helping that victim who has suffered an accident, you have committed a moral wrong. There is no legal duty on your part to take that person to hospital unless you have committed that offense. So if you just look at that person and just go away without extending a helping hand to him, you have committed only a moral wrong, because the law does not say that a person should take the another person to hospital if he finds an injured person on the street unless the offense was done by himself. So if you just pass away by looking at the injured victim without extending a helping hand to him, in such circumstances you have said to committed only a moral wrong, because you are not under a legal duty to take him to the hospital for the reason that it is you who have not committed that act. But if an ambulance driver, when he sees an injured person on the street, and if he refuses to take him to the hospital, here the ambulance driver is said to have committed a legal wrong. The reason is the ambulance driver is under a legal obligation, is under a legal duty to take the injured person to the hospital, and when he refuses, there is no excuse for him, and he is said to have committed the legal wrong as such. Next is, we said that there should be a legal damage. So the act or omission must result in legal damage. That means in the eyes of law there should be damage. So you might have suffered some damage. If the law does not consider that as a damage, again you don't have a remedy. For example, you have dug a borewell in your premises. You are getting good water from that borewell. After some time, your neighbor also digs a borewell in his premises, because of which the water quantity gets reduced in your borewell. Here you have suffered injury or damages, but that damage is not recognized by the law. So the law will not give you any remedy because your neighbor also has a right to dig a borewell and to get water. Because of that, if the water quantity gets reduced in your borewell, you don't suffer any legal damage even though you suffered the actual damage as such. So next definition is damnum sine injuria. Damnum means monetary loss or discomfort, sine means without, and injuria means infringement of legal right. So this means that causing of damage without violation of legal right. So a person's act might cause damage to you, but he has not violated any legal right. So in such circumstances, the court will not come to your rescue or you don't have a remedy in the law. The best example for this is Gloucester Grammar School case. In this case, what happened is the plaintiff, he started a school first and he was getting sufficient number of students and he was also earning good income. After some time, another neighbor started another school beside his school, as a result of which certain students from the first school joined the second school, because of which the first school suffered monetary loss. So it came down in the number of strength, as a result of which the first school suffered monetary loss. So the first school, that is Gloucester Grammar School, they went to the court and they said, because my neighbor has also started a school, some of my students has joined his school, because of which my revenue has come down, so I have suffered damages, so I am eligible for the injury. That means to say I am eligible for damages. The court said that even though you have suffered the monetary damage, your right has not been violated. That means there is no violation of your legal right. Starting a school, everyone has a right. So everyone has got right to commence a school as such. So because your neighbor has also started a similar education, because of which you have suffered monetary damage, but that does not also make you to suffer legal damage as such. So because none of your legal right has been violated, even though you have suffered monetary damage, you don't have any remedy under tort. This was the principle that was laid down in this particular case as such. The next is injuria sine damnum, that is exactly opposite to the damnum sine injuria. In this case, what happens? There is an injury, but the person does not suffer any loss. So the best example of this is the Ashby versus White. In this particular case, what happened? Ashby, who was eligible to vote in an election, he went to the polling booth, he wanted to vote for a particular candidate, but his name was not found in the list of voters, as a result of which he was not allowed to vote. Next, the person to whom he wanted, he won the election. After that, Ashby, he filed a case in the court saying that he has suffered injury. That means his legal right to vote has been restrained, or he has suffered injury because he was not allowed to vote because of the mistake of the election authorities, because his name was not found in the list of voters without any valid reason. The defendants took the contention saying that no doubt Ashby was not allowed to vote because his name was wrongly missing from the list of voters. But he wanted to vote a particular person, and that particular person has in fact won the election. So Ashby has not literally suffered any damages. The court said that here, yes, Ashby did not suffer any damages because the candidate to whom he wanted to vote has literally won. But still, his voting right has been violated. He had a right to vote, and that was not allowed to be exercised because of wrongful missing of his name in the list of voters. So he has suffered some injury. That means his legal right has been violated. So even though he has not literally suffered any damages, he has to be awarded some compensation for violation of, that means there is injuria, that means there is a violation of legal right without any damage as such. Next is, what is legal remedy? So the third condition of liability for tort is legal remedy. This means that to constitute a tort, the law must provide some legal remedy for the wrongful act caused by the defendant. That means to say, when a person does some act or violation, and if that act or omission causes damage to the other person, that act or omission must have considered as legal wrong by the law enforcing agencies. That means the court should consider the act or omission as legal wrong. As I said in the beginning, if it is only a moral wrong, then in such circumstances it is not a legal damage. So next is actus non facit reum nisi mensit rea. So mens rea means actus non facit reum nisi mensit rea. That means to say, an act itself is not an offence unless it is done with a guilty mind. That means if I commit some act, because of that if any other person suffers injury, just because my act resulted in injury to the other person, that itself will not become an offence unless I did that act or omission with the intent to cause harm to the other person. So intention is very, very important here. So what are the different kinds of tortious liability? We will examine one by one. Liability for inevitable accident. Such liability arises in cases where damage is done by the escape of dangerous substance brought or kept by anyone upon his land. That means when a person brings and keeps something in his land which is likely to result in damages to other person, in such circumstances the person is liable for tortious liability even though he had intention or not. So we can say that this is an acceptance to mens rea, or this is an exception to mens rea. So the best case is Rayland versus Fletcher. In this case, the court said that two conditions are very, very important to apply the rule of Rayland versus Fletcher. One, there should be an escape from a place of which the defendant has occupation or control to a place which is outside his occupation or control. And next is non-natural use of land. That means the defendant is liable if he makes a non-natural use of land. So in this particular case, what happened? Fletcher, he stored huge quantity of water on his land and without any reasons. So when huge quantity of water was stored on his land, the water escaped to the land of Rayland through some unused shaft which was connecting two lands, and because of this the water escaped to the land of Rayland, and Rayland had stored coal in his particular land. Because the water escaped from the land of Fletcher to the land of Rayland, Rayland who had stored coal, all that coal became wet and it became non-usable or it became useless. So here the Rayland, he went to the court and he said Fletcher had stored huge quantity of water on his land. So the land was not used for the natural purpose. Such a huge quantity of water was not necessary for him to store. So when he made use of his land for non-natural purpose, and when that particular thing escaped to that of the neighbor's land, in such circumstances, the person who allowed the non-natural use of land, he is liable for damages to the other person who has suffered damages because of it. So this is one exception to the general rule of mens rea. So here mens rea is not an essential element as such. Next, liability for inevitable mistake. Such cases where a person interfere with the property or reputation of another, then in such circumstances he is said to have committed an offence of tortious liability. So vicarious liability for wrongs committed by others. So responsibility in such cases is imputed by law on grounds of social policy or expediency. Example, liability of the master for the act of the servants. So in these circumstances, what happens is, when a master appoints a servant, and if the servant does something negligently, because of that the plaintiff suffers any damages, or if plaintiff right is violated, then master is responsible for the act of the servant. This is known as vicarious liability. So vicarious liability means indirect liability. So for the act of the servant, master becomes liable. The master cannot tell that the act was done by the servant, so servant has to be held liable. No, because it was the duty of the master to appoint a servant who is prudent enough to understand what he does. So for the act or mistake of the servant, the master is held as vicariously liable as such. Next exception is strict liability. In case of strict liability, mens rea is not taken into consideration. So the first one is consent by plaintiff or consent of plaintiff. So what is consent of plaintiff? When the plaintiff himself has consented to suffer injury or harm. In such circumstances, after suffering injury or harm, the plaintiff cannot complain against the defendant. For example, a person agrees to participate in a boxing competition. So in the boxing ring, two boxers fight each other. One person suffers huge blow, because of which he may suffer injuries as such. So the person who has suffered injury, he cannot file a case against the other boxer saying that he has caused injury to me, so he is liable to pay damages. Here, by agreeing to participate in the boxing match, the plaintiff has consented to suffer injury, because the plaintiff should have known that when he participates in the boxing match, there is every possibility that he may suffer injury, he may receive some blow from the opposite party. So as such, agreeing to participate in the boxing match itself, it amounts to giving consent for the injuries that may be suffered by such person. Next is act of third parties. So where the plaintiff suffers not because of the act of the defendant, but because of the act of the third parties, in such circumstances, the defendant cannot be held responsible for damages to the plaintiff as such. For example, I am having a dog in my house. I have locked the gate and have kept my dog inside my compound. A boy who was passing near my house, mischievously he comes, opens the gate and he runs away. Because of that, my dog comes out, and the person who was walking on the street, my dog chases him and he bites my dog bites that particular person. Now the question is whether I as a dog owner is liable to the person who have been bitten by my dog. Here the answer is no, for the reason that I had taken precaution by keeping the dog in my house and locking the gate. The gate was opened not by me or by my servant, but it was opened by a third party against whom I have no concern, or with whom I have no connection at all. So when the act is done by the third party, and if the plaintiff suffers any injury, the defendant cannot be held legally responsible for such act. Next is statutory authority. When a law enforcing agency does some act as per the law, because of which if any person suffers injury, in such circumstances you cannot prosecute the statutory authority as such. For example, a person he is going to his office, so the police officer he stops the vehicle to examine the documents of this particular driver. So in that process, this particular vehicle driver he loses some 10 or 15 minutes, as a result of which he goes late to the office, or maybe he was trying to catch a train, he could not catch the train. So in such circumstances, the statutory authority or the police officer who was checking the license or the documents of this vehicle driver, he cannot be held responsible, saying that look, you stopped me to examine the documents, because of which I missed my train, or I could not board the train, or I could not go to the office in time. So that person cannot be held as responsible for doing his statutory authority. Next is act of God. Act of God is also known as vis major. That means a person cannot be held responsible for anything that happens beyond his control. For example, I have grown a coconut tree in my house. A person is walking on the street. Accidentally, because of huge wind, one of the coconut it falls on the person who was walking on the street. As such, he suffers injury. Now the question is whether I should be held responsible for the injury that is being suffered by the person who was walking on the street, which resulted because of the coconut falling on his head. The answer is no, because the coconut was not dry that it was likely to fall. So there was no chances that the coconut was to be falling, but because of the huge wind, the coconut fell, and the falling of the coconut was not because of my act, it was something beyond my control. Let us take another example. A person is walking on the street. Because of huge wind, an electric pole falls on that person and he suffers injury. Now the question is whether the Electricity Authority is liable for this act. The answer is no if the Electric Authority was not negligent. If the electric pole fell because of huge rain or huge wind which the electric authorities had no control, in such circumstances we consider that as act of God and the person cannot be held liable or the defendant cannot be held responsible. Next, escape due to plaintiff's own default. Now for example, my friend comes to my house. There is a board displayed on the gate, be aware of dogs. In spite of that, he opens the gate and he comes inside and my dog bites him. Now the question is whether I am responsible for my friend for having got bitten by my dog. Here the answer is no for the simple reason because the dog bit him because of the act of the plaintiff. Plaintiff, on seeing the board that is displayed that be aware of dogs, he should not have entered my compound without my permission or without intimating me. So when he suffers injury because of his own default, then I cannot be held responsible. These are the exceptions to the rule, strict liability. Next, vicarious liability. So vicarious liability means liability for the act not committed by the defendant but by some third parties. So vicarious liability means where a person may be held liable for the tort committed by another person and not by himself. So the examples are principal and agent. For the act of the agent, the principal is responsible. For example, if a principal appoints a pygmy collector as his agent, this agent goes and collects money from various customers on behalf of principal, and if the agent runs away with the money, the principal is held liable for the act of the agent. Next is partners. So partners of partnership firm, they are vicariously liable for the act of other partner. So one partner becomes liable for the act of the other partner. If one partner commits a fraud to a third party, the other partner is also equally responsible even though he did not participate in the fraud as such. Next is master and servant. Again, for the act of the servant, the master is responsible. If the servant does not carry out the instructions of the master properly, and if a third party suffers any injury, the master is vicariously responsible for the act of the servant as such. Next is employer and contractor. For the act of the contractor, the employer is held responsible. But there is an exception where the contractor is an independent contractor. So who is an independent contractor? A contractor to whom it is told what is to be done, but it is not told how it is to be done. In such circumstances, for example, if I hire a contractor and I give him a building plan and I tell him that I need you to construct a building of this as per this particular plan, and if I don't tell him that how many hours he has to work, whom he has to employ, etc., etc., in such circumstances he is considered as an independent contractor. So if that independent contractor commits any mischief or commits any tort, the employer cannot be held responsible because the employer has told him only what is to be done, he has not told him how it has to be done. So for the act of the independent contractor, the employer is not responsible. But if the contractor is not an independent contractor and if the employer gives him instructions what is to be done, how it is to be done, in such circumstances, again for the act of the contractor, the employer becomes liable. There are certain exceptional circumstances where the employer can be held liable for the act of independent contractor. What is that? If the employer authorizes the contractor to do a wrong. So if the employer appoints a contractor and makes the contractor to do something which is illegal. In such circumstances, the employer cannot take the shelter saying that the contractor is an independent contractor. If the work that is assigned to the contractor is a legal wrong, then in such circumstances, for the act of the contractor, the employer becomes vicariously responsible. In case of strict liability, so again, as we already discussed, in case of strict liability, a person becomes liable even though he had intention or not. So where the contractor does something mischievous, so where the strict liability is applicable for such acts, in such circumstances, the employer is held responsible for the act of the contractor. Next is negligence of independent contractor. So where the independent contractor acts negligently. In such circumstances, so where the independent contractor acts negligently, in such circumstances, for the negligent act of the independent contractor, the employer becomes responsible. As next, torts or wrongs to personal safety and freedom. So if a tort is committed to a personal safety or freedom of a person, in such circumstances, the person is said to have committed a tortious act. So the first one is battery. What is battery? Battery means any direct application of force to another individual without his consent or lawful jurisdiction. So if I slap a person or if I hit a person without the consent of the other person, in such circumstances, I have said to have committed an offence of battery. So even though I did not slap the person hard, even though I did not cause any injury by slapping him, but by slapping him without his consent, when I have applied the force, however minimal the force may be, my act is said to be an act of battery, for which I have said to have committed a wrongful act. The next one is assault. Assault is any act of the defendant which directly causes the plaintiff apprehension of contact with his person. For example, if I take a knife and if I just swing it towards the plaintiff saying that, see, I am going to kill you, even though I don't touch the plaintiff with my knife, but still my act created an apprehension in the mind of the plaintiff, that the plaintiff feels that I might cause him some bodily injury. So even though I just swing the knife towards the plaintiff, even though my knife did not touch the plaintiff, but my act or conduct, it caused sufficient apprehension to the plaintiff that the plaintiff felt that I may cause him injury. In such circumstances, he is said to have committed an assault. So what is the difference between battery and assault? In battery, there is use of force. Physical contact is there, even though however minimal it is. But in assault, there is no physical contact, but my conduct is, or my conduct causes an apprehension on the mind of the plaintiff that I may cause some harm to him. In such circumstances, I have said to have committed an offence under the tortious liability as such. Next is bodily harm. So bodily harm means a willful act of defendant calculated to cause physical harm to the plaintiff, and in fact causing physical harm to him is a tort. So if I intend to cause some physical harm to the plaintiff, and if I literally cause him physical harm, so I just want to cause injury to the plaintiff, so I slap him, I kick him. In such circumstances, I have said to have committed an offence of bodily harm. Next is bodily harm always doesn't mean that there should be some physical injury. For example, falsely imprisoning a person without lawful justification is also said to have caused bodily harm, because by falsely imprisoning a person, I have restricted the movement of that particular person, so he cannot move freely. I have said to have committed a offence of bodily harm. Next is malicious prosecution. What is malicious prosecution? Malicious prosecution means false prosecution. That means filing a false case against the defendant with the intention to cause mental harm to the plaintiff. That is known as malicious prosecution. Malicious prosecution means filing a false case or prosecuting falsely the plaintiffs to cause a harm to the plaintiff as such. That harm need not be physical harm, it can also be mental harm, or it could be a harm of reputation that amounts to malicious. So what are the elements that is required to constitute a malicious prosecution? One, there must have been a prosecution of the plaintiff by the defendant. The defendant must have acted maliciously, that means with an improper motive. The plaintiff must have suffered damages as a result of the prosecution, and the prosecution must have terminated in favor of the plaintiff. That means to say, the defendant has filed a case against the plaintiff, that is, we are not talking about this case, some other case, and that case was a false case, and that false case was filed by the defendant against the plaintiff deliberately in order to cause harm or disrepute to the plaintiff. And in that particular case, the plaintiff was acquitted or he was absolved from all the charges. So in such circumstances, the defendant is said to have committed an offence of malicious prosecution, as a result of which the plaintiff becomes entitled to claim damages. Next type of tort is nervous shock. In nervous shock, there will be no body injury, but a person may suffer nervous shock because of the act of another person. For example, an old woman and a man was standing together in a balcony of their house. They were facing towards the road, and they see a motorcyclist driving very rashly on the street, and after that he skids from the motorcycle and he suffers injury. This scene was witnessed both by the old woman and the man, and the man tells the old woman, look, that person who fell down from the motorcycle, he appears to be your grandson. Because of the words of this man, the old woman suffers nervous shock. She thinks that her grandson has suffered injury by falling from the bike. Finally, it turns out to be some other person and not the grandson of this old woman. Here, the man who told that old woman, see, the person who fell from the motorcycle is your grandson or appears to be a grandson, is said to have committed an offence. Because of his words, the old woman suffered nervous shock. So here, the man is responsible for having caused nervous shock to that old woman, and that old woman can claim damages. So here, when we talk of damages, it need not have to be always physical harm or visible harm. Even internal injury or nervous shock can also be considered as a harm or injury. Next is defamation. When a person defames the character of another person without any lawful justification, the person is said to have committed an offence of defamation. For example, if I, without any justification, call a person as a thief, and if that person is not a thief, I have said to have committed an offence of defamation as such. So the defamation is an attack on the reputation of a person. So here it is not a physical injury, it is an injury on the reputation of the person. So there are two types of defamation. One is libel, where it is a visible representation. For example, if I write on the wall, Mr. X is a thief, then in such circumstances I have committed an offence of this libel. Next is slander. Slander is by speaking. That means if I say in front of a gathering that Mr. X is a thief, then in such circumstances I have committed an offence of slander. So both libel and slander is an offence as such. Next, till now we have discussed what is torts and what are the acts that constitute torts. So friends, till now we have discussed what is tort, what are the circumstances which will lead to the tort, and what are the acts of a person which can be called as tortious act. Now we will see what are the remedies available to a person when he suffers tortious act from the hands of the defendant. The first remedy is judicial remedies. Judicial remedies means the remedy available to a person from the court of law. So a person can claim damages or compensation from the defendant for having suffered any monetary loss. Next is the plaintiff can seek an order of injunction against the defendant in case of when he suffers any violation of his personal right in the form of Torts Act. What is injunction? Injunction we have already studied under the Code of Civil Procedure. Injunction means to do or not to do something. When a person is attempting to do something which he is not legally bound to do, or when a person is refusing to do something which he is legally bound to do, we can request the court to direct the other person to do what he is supposed to do or stop from doing which he is not supposed to do. For example, a police officer, he refuses to register my complaint. So I can get an order of injunction where the court directs him to do his duty, that is register the complaint. So next is negative injunction, that means stopping a person from doing something which he is not supposed to do. For example, my exams are approaching and I am studying for the exam. My neighbor, he plays music very loudly in his house. So I can get an order of injunction against my neighbor where the court will tell you don't play the music loudly. So again it is also an injunction not to do something. The next is specific restitution of the property. What is specific restitution of the property? If somebody without any lawful justification has snatched my property or has taken my property and refuses to give back my property, in such circumstances I can request the court to direct that person to give back my property. For example, my friend borrows my mobile, says he wants to speak to somebody else. I lend him my mobile. After speaking, he keeps the mobile with himself and refuses to give it back. So in such circumstances, I can request the court to direct my friend to restore the property back to me. Next type of remedy is extrajudicial remedies. That means remedy which is available outside the court. Friends, law does not want us to be cowards. The law does not want us to go to the court for every small thing. The law expects us to defend ourselves in case of necessary circumstances. So that is why in order to give such powers, the law has given certain remedies which are known as extrajudicial remedies. For example, if a person comes to hit me or if a person starts hitting me, I need not have to simply keep quiet, take the blows, then go to the court and say, see, he has hit me so badly, because of that I have suffered so much of injury. When a person without any lawful justification hits me or comes to hit me, in my self-defense, I can defend myself by using reasonable force against him so that he is prevented from hitting me. That is known as self-defense. So I will not be prosecuted for hitting him back because I did this to defend myself. My act was in purely self-defense. So the court don't expect me to take the blows, then go to the court and file a case against the person who has violated my right as such or who has caused bodily harm to me. Next is prevention of trespass. If a person who is walking on the street, if he tries to enter my compound or my house without my permission, I need not allow him to enter my house illegally, sit in my house, then go to the court and say, see, this person is sitting in my house illegally, send him out. I have every right to use reasonable force to prevent that person from trespassing to my house. So I can push him back out of my compound, I can push him back out of my house to prevent him from committing the act of trespass. So for having pushed him out of my compound, I will not be prosecuted for causing any injury to him because my act was to prevent that person from committing the offense of trespass. Next is re-entry of land. Presume that a person comes to your house, he just knocks you out of your house and he sits in the house. Again, you are not expected to go to the court and tell the court, see, this person has thrown me out of the house, help me in getting him back. You have every right to re-enter your house where you have been knocked out. So again, you have every right to re-enter the premises which lawfully belongs to you. So these are some of the extra remedies. In addition to that, there is also another remedy known as recapture of goods. As I said that if somebody asks you to lend your mobile and he refuses to give back the mobile, you can take back that mobile using reasonable force. You are not expected to go to the court and say, this person has taken my mobile, so please help me in getting back. Of course, you have a right to do that, but if you have no time for that, you also have a right to use reasonable force to take back your goods. So, to sum up, extrajudicial remedies are where an act is done in self defense or to prevent a trespass or to take back your property or to re-enter your land. So, to do this you can use reasonable force. Again, next is abatement of nuisance. So, whenever somebody is causing nuisance, for example, your neighbor has grown a tree in their house, certain branches of the tree have extended to your compound. Because of that, the leaves are falling continuously and you are finding it difficult to keep your premises clean. You have every right to cut out those branches which have come within your compound. So, that falling of the leaves is causing nuisance to you. To prevent or abate that nuisance, you have every right to cut out those branches which is extending to your compound. But to do this, you have to give a notice to your neighbor. See, your branches, the tree which are grown in your compound, the branches have come to my premises and it is causing nuisance. So, I am going to cut those branches. So, you have to just notify your neighbor the act what you are going to do, and your act should be the minimum act. That means just because few branches of your neighbor's tree has come to your premises, you cannot cut the entire tree itself. So, your action should be in justification to the nuisance. So, while doing so, again you have to take all the precautions. So, again while cutting the branches, you have to take precaution to see that branches unnecessarily does not cause damage to the property of your neighbor. Next is distress damage feasant. That means an occupier may lawfully seize any cattle or any chattels which are unlawfully on his land doing damages. For example, your neighbor's cow, it barges into your compound, it destroys all the plants which you have grown. So, in such circumstances, you can tie that cow and keep in your house till the owner of that cow comes, gives you the damage, and then he can get the cow released as such. So, distress damage feasant means when any animal barges to your premises and causes any damage. In such circumstances, you have every right to hold that animal with you till the owner comes and compensate you for the damages that is caused.